Kia ora and welcome everybody to today's webinar on top employment law changes to look out for in 2023. Firstly, thank you all for taking time out of your busy schedules to join us today. It looks like most of you are here already. However, we'll give the rest of the attendees another minute or so to join, so please bear with us. All right, I think we're about ready to go. Welcome everyone once again to today's webinar. Look, today's topic was chosen as it's looking to be one of the biggest employment law changes in New Zealand in a very long time. If we've learned anything from our sister company in Australia who deals with the awards system over there, it's that this is a constantly changing landscape where so much resource needs to be allocated towards compliance in the HR space and also just keeping yourself up to date with all of the changes. So although it's still a fairly early on in the piece, we're hoping that today we'll be able to provide clarity around what's been introduced so far. Next slide, please. Thank you. Before we get started, I'd like to introduce you to today's speakers. As you've probably already guessed, I'm Mark Stewart, and I'm a Business Development Manager here at HR Assured. You won't be seeing too much of me today, however. Basically, I'm just here to introduce our other speaker for the day. That's our compliance guru, Vaughan Granier. With over 30 years of international experience in law and HR management, he's led organizations in South Africa, the Middle East, Australia, and New Zealand through significant workplace change while ensuring employment law and health and safety compliance. Before I invite Vaughan to start his presentation, I'd just like to give you all a quick rundown of what it is that we do here at HR Assured and the benefits of using our service. Essentially, HR Assured is your external HR and health and safety partner for your business. Our slogan is avoid the admin, create the culture. We understand you don't want to be spending too much time ensuring that you're meeting legislative requirements. Ideally, you're spending that time growing your business. How do we do this for you? Basically, when somebody comes on board, the first thing we do is perform a comprehensive HR audit. This will help us to diagnose where any gaps there may be within your HR documentation and processes, and we will then work with you to fill those gaps and ensure that you're meeting your obligations. You'll also have access to our 24/7 telephone advisory service. Any minute of the day, you'll have a qualified professional on the other end of the phone, ready to provide advice on your HR queries. You'll also get access to our cloud-based platform, which is named HRA Cloud. This is our online platform to manage, track, and record all of your HR and health and safety data. HRA Cloud also contains a library of legal resources, which is constantly updated to ensure that you're up to date with current legislation. And finally, the insurance and representation. So we back our team 100% with the advice that they're giving over the phone. So if you've followed advice from us and a claim comes up against you, the insurance policy can respond, which covers up to $2 million in damages for any 1 year. You'll also see on the right that we also cover health and safety. Similar to what I've just mentioned around HR, we can perform a health and safety audit. You'll get access to the telephone advisory service, which you can also call through with health and safety matters. And HRA Cloud also contains a module which is dedicated solely to health and safety. It has a massive library of resources available to you and all sorts of different processes there as well. If this is something that you think you'd like to hear a little bit more about, my contact details will be popping up in a few slides later on, so please don't hesitate to get in touch. I'm sure that throughout the presentation today, you'll probably have some questions. If you look towards the bottom of your screen, you'll see there's a Q&A feature where you can ask your questions. So towards the end of the presentation, we'll be taking time to answer as many of these as we can, time permitting. If we don't get to your question, we'll do our best to follow up as soon as we can after the webinar. So that's about it from me. I'll now be passing you over to Vaughan.
Thank you, Mark. I really appreciate your introduction there, and thank you for the clarity you brought to the opening scenes of this presentation. So everyone, today, welcome. We are looking at 2023 as a year of significant change in New Zealand's labour law environment. There were originally a lot more changes planned for this year. Obviously, with Jacinda Ardern stepping down and Chris Hippins coming in, there has been what they've been calling a policy bonfire, where a lot of policies, including a number of employment law changes, have been ditched in favor of Labour paying attention to certain more important policies and ensuring that they get some results on those specific areas. So the overall size of this presentation has shrunk in terms of policies and procedures that have been bonfired by Chris Hipkins, but there still remains quite a bit to get through. So let's get started. So we're going to look at the following items today. The first one we're going to look at is fair pay agreements. Now, fair pay agreements are a copy from the Australian system. Mark, next slide, please. All right, so fair pay agreements are known to be the biggest shake-up to industrial relations in New Zealand. A number of decades ago, there was a similar system to fair pay agreements, which was ditched in favor of an open employment market. And now the Labour government has sought to return us to a fair pay agreement system. Now, this is largely copied from the Australian system of awards, and it's chiefly driven by Labour's promise to increase the power of the unions. So there is significant legislation available in New Zealand which can prevent exploitation of workers and make sure that minimum rights are protected. But there is a definite agenda here to ensure that the unions who enable the Labour government to be elected are rewarded in terms of their loyalty, and the power base is increased. The power base was higher, but it's now at about 17%, and they're hoping to increase that significantly throughout the workforce in New Zealand. So the fair pay agreements are going to give particular focus to setting minimum wage rates, ordinary hours, overtime, and penalty rates. And they will also look at things like redundancies, leave entitlements, and health and safety. These are dependent on what the union demands in a fair pay agreement negotiation. So there's no guarantee of what issues are going to be raised, and no limits to what kind of issues can be raised. But the unions will set their demands for a sector or an industry, and the bargaining process will happen from there. Currently, there are only 3 applications being assessed. So we have a hospitality-related application, an interurban, rural, and bus transport application, and a supermarket and grocery store application. So that's largely in the retail industry. Now, these are the most important ones that are the priority. But as you'll see on the next slide, there are a few other areas which are being targeted in the near future. So security workers are known to be a vulnerable area of the economy, retail workers outside of supermarkets, and also the cleaning industry. So these industries are known to be high risk in terms of exploitation, where a lot of migrant workers are employed. And so it's highly likely that unions who are focusing on these areas will shortly be launching fair pay agreement applications. The most important thing we can look at for you as employers is what can you do to get ready, because all the publication around fair pay agreements has largely been about what to do with a fair pay agreement or how they're going to affect the workplace. But there's a significant amount of planning that's going to precede a fair pay agreement, and it's going to involve a lot of work by employers who perhaps don't have a lot of familiarity with these responsibilities. So what I want to do over the next few slides is simply take you through what employers need to do in order to be ready for fair pay agreements. Okay, so the first couple of things that are important to note, that you need to be aware and organized. That's critical. You cannot be an employer who doesn't even know that there's a fair pay agreement application in place for your industry. You cannot be an employer who doesn't know who to talk to about these things. And you cannot be an employer who is trying to go it alone and do things by themselves. That simply won't work. Okay. Employers must be part of an eligible bargaining party. You cannot try and negotiate a fair pay agreement as an individual employer. You have to be recognized as part of a bargaining party. Now, bargaining parties have their requirements, which I'll get into on the next slide. But if you do not participate, you will end up being subject to a fair pay agreement to which you had no input. So it's really important that as an employer within an industry, you find a way to make your voice heard, so that if you have priorities, if you have limitations on what you believe you can do, that those limitations are at least communicated into the bargaining party so that they can put them forward at the bargaining table. And the problem with all of this is if you don't get involved, and if there isn't a fair pay agreement successfully negotiated, then the ERA can set up the terms of a fair pay agreement if the employer does not participate. That means the ERA will decide what the correct terms are for your business, and they are not the right people to make that decision. It needs an employer party to negotiate on behalf of employers. All right, so what's next? So the employer bargaining party is a group of employers who must represent an entire industry, even the non-members who are in that same industry. So if there are 5 employers who gather together and become a bargaining party, but there are 50 employers within the same industry, then those 5 employers need to understand and know all the dynamics that even the non-members of the bargaining party are facing, so that they can adequately represent them. The bargaining party must apply to MBIE and get accredited. You cannot arrive at a bargaining forum if you are not accredited to bargain on behalf of the employers. There will need to be a signed inter-party agreement, so there will probably be lawyers involved here, or at least significant planning and preparation, so that an inter-party agreement can be signed between the employers that they work together and represent each other. And there also needs to be a chosen bargaining representative. This is an individual, somebody who will be the lead advocate, the chair of the bargaining party, and also the primary spokesperson during negotiations. The eligibility requirements for an employer bargaining party is that they must have at least one member who is a covered employer by the agreement. So you cannot have a bargaining party that has no skin in the game and no stake in the outcome. It must be an incorporated society with a registered constitution, and that constitution must enable the association to represent the collective interests of employers. Now, the reason I highlight that is because a lot of employers have association bodies, but their constitutions will not yet cover off the purpose of collective bargaining on behalf of employers. So even though, for example, there is a employers association around the cleaning industry, that does not guarantee that that association is already accredited and ready to negotiate. They need to fulfill the requirements to be a bargaining party on behalf of the cleaning industry. And then obviously it operates independently from any union or worker organization. That's really important because you can't have a conflict of interests where an employer body might have interests that it is arguing against in its own presentations. All right. Now, currently, what's really important to note is that there are no applications to register as an employer bargaining party. What that means is that employers are behind the 8 ball. There are applications for fair pay agreements already in place, and there are no employers ready to handle those applications if and when they become necessary to do so. So it's really important that employers get together and talk and begin the process of setting up employer bargaining parties so that there can be representation on behalf of employers for fair pay agreements. Thank you. For next slide. So just to give you some idea around the timelines, which will give you some either comfort or strike fear in your hearts. So once a union application is lodged and has then been approved by MBIE to be commenced, that means that the union has successfully lobbied for the right to represent employees in a particular industry. Employers will have 3 months to form an employer bargaining party. Now, 3 months is not a long time if you've done no work in the past, so I suggest that employers begin to work relatively quickly to become familiar with the requirements here. If they don't form an employer bargaining party within the first 3 months, there will be 1 further month for Business NZ to agree to be the default bargaining party if it wishes to. If it doesn't, the union can then apply to the ERA for the fair pay agreement terms to be set. Now, what that means is that there will be terms set for an entire industry that has had no input from any employer. That means that the terms will be subject only to what the union has advocated would be fair and reasonable terms, and that probably will not be what the employers agree to. So it's highly, highly important that employers get ahead of the game and begin to organize themselves. What employers have to do in the course of becoming members of a fair pay agreement is, one, you have to provide information to the unions and to the employees. You have to allow attendance at fair pay agreement meetings. That would be unions holding fair pay agreement meetings on site. You have to allow a fair pay agreement representative access to the workplace so that they can talk to employees about it. And you are required to provide an electronic record of employee details. So that would be all of your employees, whether or not they have consented to be a member of the bargaining of the fair pay agreement or have any objections to it, you are required to provide that information to the unions. All right, thank you. So the fair pay agreement system, you've all probably seen this graph many, many times before, this infographic, but it basically sets out how we are going to approach fair pay agreements. So we have 3 initiation lodged with the MBIE. So we can take one of those as an example. So say, for example, the retail industry. The union has collected evidence to demonstrate that it meets the requirements of or public interest that so that they can begin bargaining. Those applications are currently in this stage. If they are found to have met the requirements, then they can propose a bargaining forum, and we have 3 months as employers to get to the table with a party and a further month to get Business NZ at the table. Once bargaining starts, there is a bargaining process where you can have 2 passes at trying to reach an agreement. If you negotiate and fail to reach an agreement, you then go to dispute resolution. They will try and help you resolve it, and they will then return you to the table to have another round of bargaining. If that bargaining fails as well, you go back to dispute resolution. And if you cannot resolve it and come to agreement at that stage, then the Employment Relations Authority can decide the terms of the fair pay agreements at that point. If you do manage to reach agreement, then you'll go to a ratification vote by your members, and then the fair pay agreement will be in place. All right, so that's the process of that happening. But for this to happen, it requires the employer bargaining party to be in place, or there will be no voice for employers at this table. Then the process will go down the right-hand side of this graph as opposed to the left-hand side of this graph. Thank you. Okay, so we have obviously what Mark said earlier in the introduction is that our Australian sister companies have dealt with this before, and they indeed have. The Australian award system is decades old now. The modern award system began in 2010, and they have 126 awards, I believe, that cover all of the possible industries in Australia. Now, you may think 126 is a lot, but it started out at well over 1,000. So 126 is a significant reduction in the number of fair pay agreements. However, what we can tell you from our Australian sister company is that compliance is very complicated. The fair pay agreements are all individual per sector. So there are many different fair pay agreements. They have different categorizations. They have different responsibilities placed on employers. For something as simple as overtime, you can have different rules that apply to when overtime kicks in and when it doesn't. So there's a lot of complexity coming our way in terms of how these documents are drafted and how they are prepared, and how, for example, they avoid conflicts. So you can have 2 parts of an agreement that conflict with each other because the drafters are not excellent drafters. It is possible that this happens. So there's a lot of requirement for compliance, and the cost of compliance will grow because there are many, many issues requiring interpretation and guidance. The consequences of errors can be exponential and arduous to resolve. And the headlines in Australia have told us recently of back pays that are in the hundreds of millions of dollars for large companies. Obviously, they won't be that large for smaller companies, but you still are going to find, for example, that a company for a year has been using the wrong calculation or the wrong formula. A union discovers this, and now you get back pay for an entire year. So this kind of thing could happen, and it's important to realize that that is a reason why companies must be careful not to make mistakes up front. The costs associated with making a mistake and having to correct it later can be out of proportion to the effort required to prevent the mistake in the first place. It's important to note that New Zealand payrolls are not yet built for the complexity required. So payrolls run on rules, if this, then that. And there will be a lot more rules that are required to be programmed into payrolls in order to adjust to fair pay agreements. Now, those rules will not be set up quickly. There will be lots of errors. There'll be lots of trial and error in the programming side of things. So we're not going to have guaranteed compliance from day one, because only when a fair pay agreement has been finalized will payroll systems be able to develop the complexity required. So we're looking at a period of time where the responsibility will be in place, but payrolls may well not yet be equipped to handle that complexity. What we can tell you is that our sister company in Australia has significantly higher call rates than we do currently around compliance issues. And that's simply because there are more compliance issues in Australia due to the modern award system. One of the examples I can give you of this is that you can have a single workplace where a lot of different multiple agreements will apply. So for example, you can have a manufacturing facility that also has a warehouse, okay? And what you'll have then is a manufacturing agreement for the manufacturing area of the business, a warehouse agreement for the warehouse and logistics area of the business, and administrative agreement for the head office where they're doing all the admin and the payroll and things like that. So you can have 3 different agreements in a single workplace, all with different conditions of employment. Currently, that's in Australia. I think that in New Zealand, they have been aware of this problem and they are trying to create rules that will make sure that only one agreement applies in one workplace, but we don't yet have any idea if that's going to work out. So there are complications and we can predict them from the Australian award system and perhaps give guidance and give advice in advance that can help us to avoid those multiple hurdles. Okay, next slide, please. Mark, we're back to you.
Back to me. Thank you, Vaughan. Great start to the presentation. Look, we're already seeing a steady stream of questions coming through. So remember to keep firing those through. And at the end of the presentation, we'll answer as many of those as we can. Now, one of the few positives that came out of the COVID pandemic a number of years ago was that people kind of learned what these things are up on the screen that you can see in front of you, these QR codes. Now, if you have any further questions around anything we've discussed today, or just basically anything at all HR related, I'd highly recommend scanning the QR code on your screen now or following the link that you can see below it. This will give you a chance to conduct a complimentary workplace compliance consultation with us here at HR Assured. If you haven't done an HR audit or assessment in a while, this would be the perfect opportunity to do so. Look, we'll look into things like your current setup of employment contracts and policies, employee issues past and present, and how to mitigate risk moving forward. And of course, the topics that we've discussed in the webinar today. It's generally just going to help us identify in a very broad sense how compliant your business is within the HR and health and safety world. And finally, there's absolutely no obligations of doing this. If you're unable to scan the QR code right now, like I mentioned just before, there is a URL there which will take you to the site to submit some details. We'll give you just a few moments now to scan that code or head over to the site, and this will give you an opportunity to throw your details in. We'll be doing the same thing towards the end of the presentation as well, but for now, that's it from me. I'll be passing you back to Vaughan.
All right, let's talk about something that's probably quite a niche sector, which is screen industry workers. If there are any screen industry-based companies here, then welcome. These are changes that are going to affect you. And I understand that most employees or most people who work in the screen industry are in fact contract workers. We understand this. They're employed for films, they're employed for productions, and then after that's over, they are on their own again until the next work comes up. So contract working is the natural order of things in the screen industry. But what that's revealed is that there are a number of cases where, because they are contractors, they lack a large number of protections and can be exploited quite significantly. So what has happened is that there has been a need for screen industry workers to be able to protect themselves. And the main focus has been around collective bargaining. So just to clarify, so an engager of a contractor worker can be a production company or a partnership or an individual or any other type of entity. If you are doing primarily screen industry work, it means that half of your average gross income from the last 3 years is from screen production work, or you've been set up in the last 3 years primarily for the purpose of creating or contributing to screen productions. If you are in that category, then you are an engager. and anyone who is a contract worker for you would fall under the Screen Industry Workers Protection. Okay, so what this means is that industry workers who are contractors can now bargain collectively. They can argue with each other on behalf of each other for greater protection in the workplace, and the screen industry employers will have to address their issues as a collective and not as an individual. What's important to note, obviously, is that a screen production worker is a contractor unless they have a written employment agreement. What that means is if they don't have a written agreement, they are a contractor. It's common in most of New Zealand businesses to have written agreements in place, but sometimes we don't. And so if you don't have a written agreement, you are in danger of having someone who is actually a contractor and is now able to protect their interests through this act. Next screen, please. There are dispute resolution mechanisms available for these people that were not previously available, and it's important to realize that. They can go to mediation through MBIE Employment Services. Apologies for the typo there. They can go to Employment Relations Authority facilitations, where they can actually try and reach a mediated settlement by working together. And if that fails, the ERA is allowed to make a determination, which is a legally binding decision, like an arbitration, like a court case, which will set the conditions for the contract worker. And obviously, people are able to resolve the issues themselves, which is, of course, the preferred way of doing it. But dispute resolution, which wasn't easily available to contract workers, is now very much available, and they can achieve certainty around their working conditions and a certain level of protection through the Screen Workers Industry Act. Okay, this is an important change. Sexual grievances are one of the more difficult ones in terms of grievances, because if there has been an allegation of harassment, often the victims are female and the perpetrators are male. Often the victims are junior in a business and the perpetrators are senior and have authority in the business. So the gradient is in favor of the perpetrator and due to their authority in the workplace and the ability to control the outcome of a harassment case in terms of the consequences. So there's a recognized to be quite a significant difficulty with sexual harassment cases, that victims are likely to not report them or to take a very long time to gather up the courage to report them. And what has been decided is that 90 days, which is the normal limit for a grievance, is actually insufficient in the case of sexual harassment cases and other sexually related grievances or disputes. And so the time period has been increased to 12 months. That means that somebody who has been harassed in the workplace is entitled to take up to a year before they report the matter, and it will still be a valid case, which will then be addressed by the ERA or the courts in this case. And that changes things quite significantly, because it means that there isn't a 90-day window beyond which a perpetrator might feel safe, and there isn't a 90-day window beyond which an employer might feel safe if they know that something has happened in the workplace. A 12-month period is a significant amount of time, and what it means is that companies would be well invested to make sure that there is a culture of protection around these matters, so that sexual harassment does not happen in the workplace, that it's highly discouraged, because the consequences of receiving a grievance after 11 months and 28 days would be significant. You may not have any ability to defend yourself by not having the documentation in place, the memory, even the employees might have moved on. You might find yourself in significant difficulties with defending a claim like this. So the best prevention is, of course, to make sure that there can be no cases in your business, because the culture prevents it from happening. So my wish and my hope is that we take this very seriously as an amendment that is designed to impact on cultures rather than compliance. Next slide, please. Okay, migrant workers. Migrant workers, as I've said before, are significantly at risk of exploitation. There are a number of reasons for this, but largely it's because they come from a country with different laws. They've grown up with different laws, and they have no real understanding necessarily of New Zealand laws and the protections that are available to them in New Zealand. So what you find is that there are many people who come over on a visa. They may quite willingly accept the conditions they're given, thinking that everything is normal and thinking that they are being treated right because they know no better. And yet there are significant breaches happening around them, which they would be able to object to if they knew better. Okay, so one of the things that's been decided is that migrant workers need greater interventionist protection. That means that more powers are being given to labour inspectors and immigration office to inspect workplaces, to access employment documentations, to go on site, to conduct inspections, to conduct interviews, and to make sure that there is no non-compliance. Significantly, employers cannot refuse to cooperate with authorities, even if they feel that if they cooperate, they will self-incriminate themselves. So effectively, somebody who breaches the law cannot try and wriggle out of it and prevent themselves from being outed as having not complied with the law. The other thing that's really important around this, and this is an area where there has been a level of protection in the past, which is now being stripped away, information can be shared between agencies. So if a labour inspector goes onto site and finds a non-compliance issue, they could share that information with the tenancy tribunal, they can share it with IRD, they can share it with the police, with the registrar of companies and WorkSafe, and as many other agencies as they feel the need to, which means that we may have a situation where a small breach has ramifications in a number of areas for a business, where IRD increases their observation of the business and checking the business, where the registrar of companies may have an issue with who are the directors of a company. WorkSafe may want to investigate various things. They might send inspections directly to the workplace. So this can have a significant impact on workplaces. So again, the idea is that migrant workers deserve and are entitled to protection in New Zealand, and their lack of knowledge or their lack of a sense of empowerment in a foreign country is going to be compensated for by labour inspectors and immigration officers supporting them by having their own powers. Okay, this is the big one. The Holidays Act is meant to be changed this year. So in 2019, you can see here that there was a task force. Everyone in New Zealand has heard about the changes that are being made. And these were made because, as I say here, the Holidays Act is legendary for its lack of clarity and its unnecessary complexity. Anybody who has run payroll will know exactly what I'm talking about. This is the Holidays Act has a nightmarish web of definitions and conditions and various classifications that make it really difficult to accurately implement it and to build a payroll compliance system that handles all of these issues. That Holidays Act task force recommended 22 changes, all of which were unanimously accepted by the government. Okay, so what we have now is the task force is going to be in a position to draft law which incorporates all of those 22 amendments. Okay, it was expected that legislation will be introduced in 2022, but obviously COVID got in the way and a lot of government processes were halted or paused while we all handled that major crisis. And now, mid-2023, we are hopeful that the Holidays Act will become law by the middle of the year or shortly thereafter, but there's no guarantee. We are a couple of years behind, so we don't know when this bill will be introduced to Parliament. What I'll do next is I'll take you through the key changes. I'll gloss over them slightly. It's far too in-depth to go through them all now, but I'll cover off the main headings and you'll get a feel for what's likely to change. The general feeling is that they hope that the complexity around calculations and definitions will reduce and it will become more simple. Unfortunately, I read an article just the other day where the Payroll Practitioners Association of New Zealand feels that this may not be the case, and the Holidays Act changes may in fact continue the complexity or even increase it. We can certainly hope this is not the case, but I'll quickly take you through all of the changes that are likely to be coming. Next slide, please. Okay, so one of the big issues is in the current law is what is a week or a portion of a week for calculating annual holiday entitlements. So annual holiday pay is calculated in weeks, but it's also broken down into hours and days, because you can take annual leave for a day, but the calculation of the pay happens on the definition of a week. So there's a lot of different competing definitions which go into this. And what they want to do is clarify exactly what a week is, or a portion of a week is, so that there's clear understanding by all parties as to how to pay for an entire week's leave, or a day's leave, or a couple of hours leave, or what, without any confusion reigning. They want to have a new test for what's an otherwise working day. Now, what you'll remember from public holidays is that an otherwise working day is a day which otherwise would have been worked by the employee. But it does create a lot of confusion, especially where Mondayization happens with public holidays, and also where shift work or rostered work means that certain days are on or off, and how many days must be off before it becomes not an otherwise working day. So there's a lot of complexity around this, and they're going to clarify the definition around what is an otherwise working day. They want to have a new test for eligibility around family violence, sick and bereavement leave. What you'll remember, our current law says that you cannot have these leaves, these types of leave as paid leave, unless you have worked for 6 months for an employer. Okay, so there is going to be a change, which means that people who might need access to this leave earlier than 6 months will probably have access to this sick leave. And the question will now be, how are they accruing it, and how will they get paid for it? There's also going to be a new concept of ordinary leave pay to replace the two concepts that exist now that often get confused between each other. Ordinary weekly pay is the ordinary pay you would receive in a week, and it's the primary calculation for annual leave. There is also average weekly pay, which is when you can't figure out ordinary weekly pay, you work out what is the average weekly pay. And then there's relevant daily pay, which is the pay model used for bereavement leave and sick leave and other leave that could be taken in a simple day amount. Okay, so all of these things create a lot of confusion as to what the right pay rate is, and they want to create a single concept that underpins all of the types of leave. Okay, again, they want to change the definition of gross earnings, because we had cases recently around commission structures and what commission falls into gross earnings. And there was a whole debate around contractual bonuses and discretionary bonuses. So this is going to be clarified once and for all by legislative definition, so that the courts don't have to get involved in defining these things. Next slide, please. There's also going to be some work around what is intermittent or regular. Now, casual employees earn pay-as-you-go leave, which means they earn 8% of their gross pay, paid in every pay run to them as a separate line item in their pay slip, which is in compensation for not being able to accrue annual leave. Okay, so obviously, because they're casual workers, they work intermittently or irregularly. But there are some gray areas around that when casuals are actually employed for a period of time and work fairly regularly during that period of time. So there will be more clarity around that. Employees currently are not able to take annual leave in the first 12 months of their employment. They are accruing it, but they're not yet entitled to it. The change that's going to be made is that employees will now be able to take annual leave in their first 12 months up to the amount they've already earned. So if you've been there for 3 months, a simple calculation is you would have earned 1 week's worth of annual leave. So you can't take 2 weeks, but you can take up to that 1 week, right? And then also employees will be allowed to access bereavement and family violence leave from the first day of their employment, which is a similar thing to what was covered up earlier. Sick leave as well will become available from the first day of employment. Paragraph 10 here, bereavement leave is going to have an increased definition to include more people. Okay, so currently you basically have a relative definition of immediate family, which includes your biological family and some step family members, and then a second definition of less intimate family members or friends. So this is going to change to include more people in the closer circle, which are entitled to 3 days worth of bereavement leave, as opposed to 1 day's worth of bereavement leave. Sick leave and family violence leave might be able to be used in units of less than a day. Currently, you can't really officially take sick leave of less than a day or family violence leave of less than a day, but they're now going to reduce that to a quarter of a day. So literally that's about 2 hours worth of leave if you have something to deal with that can be done in 2 hours. What that means is that people might be able to take sick leave to go to a doctor or to have an extended time in court for family violence leave. they would be able to take a quarter of a day's leave or a half a day's leave for those kind of things, whereas in the past, they would not have been able to take leave for that. There is a concern in the Parental Leave and Employment Protection Act that employees who take annual leave after returning from leave actually have a zero value annual leave. So the idea here is that there will be a fix to the definition of annual leave and parental leave so that they don't conflict with each other and allow employees to be able to take annual leave at full pay after returning from parental leave. Okay, they want to introduce some flexibility around close down periods. That could be in terms of the notice period for it, but also when close down periods happen and how they are managed in terms of paying leave. Next slide, please. They also want to update record keeping to reflect all these changes. So currently, record keeping is a really important part of compliance. You aren't complying if you don't keep records of complying. So they want to update those requirements so that these changes are easier to record. That will come down to a payroll issue mostly, and we can expect some complexity around that. So there would need to be a lot of work done by payroll providers to make that happen. Currently, and most people don't know this, is that there is no requirement to provide payslips. If you provide a payslip, it must have certain information in it, but there is no current requirement that a payslip must be provided in every pay period. So this is going to change that aspect of the law so that there's no more doubt that employers should always provide payslips to every employee in every single pay period. Okay. The other thing which is going to change is, and this is the last thing I'm going to cover off, even though there are 22 changes, I'm just going to cover off these 16, is that employees on the sale of a transfer of business currently don't have the choice of whether to transfer all of their leave across to a new employer or have them paid out and reset. This is going to give the choice to do that to the employee and not keep it with the employer. So currently the employer can decide how this works. The change is going to transfer that right to the employee. Right, and that's a summary of the most important changes around the Holidays Act, what you need to prepare your business for. Presuming this happens before the election this year, which I think it will, it's going to be really important to work with payroll providers to make sure that they are compliant as quickly as possible, and that they are running parallel pay runs alongside your actual pay runs to see whether they comply. I have too many cases of companies who change payroll systems or introduce new rules into their payroll processing and don't do parallel runs. And then when the errors happen, they happen live. And that creates a lot of complexity. So please make sure that your payroll providers are working hard to become compliant as quickly as possible and also are running parallel pay runs to test the changes they've made before they actually introduce them into the live payroll environment. I think the other consequence, which we don't quite realize, is that there will be an increase in absenteeism costs in early phases of employment. Because employees currently can't take paid sick leave in the first 6 months, employers don't notice the cost of absenteeism in the first 6 months except through loss of productivity. What we're going to see now is that absenteeism in the first 6 months will be payable, and there will be an actual physical payroll cost to absenteeism, which didn't used to exist. So there will be an increase, a visible increase in those costs in the early phases of employment. There will be a need to prepare new contracts of employment containing all these changes, because they will be significantly different to what the law currently is, and they may mean that your existing leave provisions are invalid. So it's worth going through and checking all of that. And then obviously, the most significant part of running businesses is that people who are leading other people need to know what the law is and how to make the right decisions so that they don't breach the law in making normal operational management decisions around leave. So if you're going to say, no, you can't take paid sick leave today because you're not entitled to it, but you aren't aware that the law has changed and they now can, then you as an organization will be breaching the law because you haven't taught your managers what the new law is. So there's a real need to look after that as well. All right, next slide, please. Okay, living wage extensions. This won't take too long to cover off, but basically there is a difference between the minimum wage and a living wage. And the living wage is going to become a phenomenally important thing for anyone who wants to obtain work from governments. Okay, so to get qualified for public sector work, employers will need to be certified as a living wage employer. Now, the living wage is calculated currently at $23.65 an hour. That is calculated as a percentage of the average median wage in New Zealand, which currently is at $34.76 an hour. So effectively, what they're saying is that if people are targeting to be a living wage employer, they should be trying to pay $23.65 as the minimum rate of pay in their business. The minimum rate of pay in New Zealand is $21.70 from 1st of April. Currently, it's 20, oh, I've actually forgotten. I've got all these numbers going around in my head, but it's currently in the region of 20, and it's going to cross over to 21.70, I think. So obviously, there's a difference between living wage and minimum wage, and it's really important that if you want to obtain work from the government, that you are certified as a living wage employer with a minimum pay rate of $23.65. Next slide, please. Pay equity is an interesting area. It does involve some challenges around privacy. Effectively, what has happened is that there is an understanding, and we all know that there are different rates of pay on average between men and women, that there's a legacy issue here which needs to be addressed. And the main thing is about setting a standard that equal pay is received for doing work that might be different, but is of equal value. So it's one thing to say that all accountants must earn the same wage, or all forklift drivers must earn the same wage. What this process is about is understanding that different work can also have equal value. So an accountant might have the same value as an operations manager or a team leader or a supervisor. And as a result of having similar value to the organization, they should be receiving similar pay. So this may have quite an impact because it can affect not so much the pay within a department, but it can affect perhaps what is regarded as equivalent or similar pay across an entire business. And you might find, for example, that a supervisor feels that they add as much value as your accountant, and then argues for equal pay to the accountant because they do work of equal complexity and equal diversity to the business. And if that changes, you might find that pay structures across a business might change quite radically. So this is not something we shouldn't take seriously, something we should take seriously, and we should make sure that we are striving to understand what the value of work is and making sure that people receive equal pay for doing that work regardless of gender. Okay, it's important to notice that claims can be made by individuals or through collective bargaining, which means that trade unions can do this on behalf of employees, or individual employees can do it by themselves. If a claim is made, there will be a determination if that claim is arguable, and if it's arguable, in other words, if it has potential merit, it will then proceed to an assessment phase where it will be assessed and found to be either valid or invalid. If it's valid, there will be a requirement to make some changes. And what they're saying here is that comparators are the basis for negotiation, which means that there will be a great deal of comparison between different roles and different responsibilities. This will not be a quick process or a simple process. It will need to be done thoroughly. And I think that a lot of these decisions and these comparisons will probably be the subject of consultation and consultants being brought in to assist with the analysis. Any disputes in this regard are going to be settled through mediation, and if that fails, through arbitration or the Employee Relations Authority. All right, so this is the process for pay equity claims. I won't go through it in detail, but it's available in the presentation and you have access to this. There are two kinds of processes. One is for individual employees and one is for collective employees. They have slight differences. The next slide is for collective employees, and we can skip through those. You'll have those in your pack.
Thank you, Vaughan. So this won't be the last we hear from Vaughan today. He'll be answering some of your questions in just a few moments. Look, just in case you missed it last time, in front of you, you'll see the link from earlier to receive your complimentary compliance consultation. Just as a quick recap, the purpose of these consultations are to help uncover any immediate risks to your business within HR and health and safety. It'll help you understand your obligations and what you need to do to ensure that you're compliant. These don't take too long to do. And once again, there are no obligations whatsoever. So I'll just give you about another 20, 30 seconds to scan the code before we move on to our final few slides. All right. One final reminder from me just about our services before we start answering some of your questions. Basically, we can be the external workplace relations partner for your business. We'll provide you with the framework, systems, and processes to ensure that you're in full control of your HR and health and safety obligations. One of our main goals is to ensure that our clients are complying with a proactive rather than reactive approach to workplace relations. My contact details will be available to you on our final slide. So if you'd like to hear anything else about our services or you want to see a demo of HRA Cloud, please feel free to reach out using those details following this webinar. And finally, this brings us to the end. Time to go through some of the questions. Firstly, I would like to thank Vaughan, and I'd like to thank everyone else for attending today. Vaughan, you have provided some really valuable content to us today, and I'm sure I'm not the only one here that's walking away with a little bit more clarity around the upcoming changes.
Pleasure.
Now, not a problem. Now, look, there is one more QR code, funnily enough, in front of you right now. It's different to the one that we had up before. We're also offering the opportunity for people to call through to our telephone advisory service free of charge. So if you do have any questions, whether it's about today's presentation, it could be any other HR related query that's on your mind. It could be something that's currently happening in the workplace at the moment. You're able to call through to the team to get a bit of an idea of how our advisory service works. Perfect. We'll give you another 10, 15 seconds to scan that, and then we will move on to the questions. All right. So it turns out there were a lot of questions that came through, Vaughan. We're not going to get through all of them today. So what we will do, though, the ones that we don't answer, we will follow up as soon as we can after the webinar and get some answers out to you all. So Vaughan, the first question is, what are the ramifications if an FPA is put in place and we don't comply?
Well, that would be the fair pay agreements are going to become what is called secondary legislation. So once an agreement has been signed or imposed by a decision at the ERA, it literally becomes law. It's not just an agreement between two people. It literally becomes secondary legislation, which means that inspectors and agents of WorkSafe or of the Labour Department can come into site to inspect to see that it's being complied with. Obviously, the main person who's going to argue that it's not being complied with is the union. So you will have to deal with a number of people who are looking carefully to see whether you've complied or not. If you haven't complied, secondary legislation by definition means that fines can be imposed, compliance orders can be imposed, and that can lead to very serious consequences for business, including the inability to employ migrants, as well as a high cost in terms of potential fines and other consequences like WorkSafe doing inspections and visits. So it has real ramifications in the real world. It's not just an agreement that can be flouted at will.
Okay. Thank you. The next question, FPAs seem complex. Can HR Assured assist our business with advice?
Absolutely. In New Zealand, most companies will be wondering what's going on because they won't have any experience of fair pay agreements. In Australia, Obviously, the companies there have significant experience, and we have a deep relationship with our Australian sister company. We have experts there who have dealt with fair pay agreements under the award system for a very long time. And all of that knowledge is available to us to assist us to predict what's likely to happen, and also to understand what are successful management strategies and preparation strategies so that you won't fall foul of this law. So yes, we are able to and equipped to provide significant advice to you that's strategic and born of experience and not just theoretical knowledge.
Perfect. And we'd love to hear from everyone. Hey, this one came up a couple of times. What is the difference between the minimum wage and the living wage?
The minimum wage, and I have still got no idea in my brain what the actual rate is. I think it's 21.20 or something like that. It's embarrassing not to know that answer when I'm the expert. So the minimum wage is the minimum wage which any employee is allowed to earn as an adult. You can earn a slightly lower amount as a trainee or as a person who's under the age of 18. But once you are not a trainee or you are over 18, then you are required to earn the minimum wage. The living wage is a higher wage. It's basically a wage that is regarded as being the right amount of money for a person to live a normal, fruitful life and not be scraping the bottom of the barrel in terms of affordability.
Okay. By the way, it was 21.20. So
there we go.
There we go. How will changes to the Holiday Act impact on payroll, and what can I do to prepare my business?
Right. Well, I did cover that off slightly, but it is worth going over again. So payroll companies work on the basis of rules. So payroll is automated because they can have a number of if-then statements running behind payroll that actually say, well, if this, then that. And payroll can automatically calculate pay rates and put the correct rates into pay. The problem that we have is that those rules are all going to change when fair pay agreements come in, and the payrolls won't know what those changes will be until the fair pay agreements come in, until they're agreed. So it's really important that that the payrolls are given time to figure out what the changes are going to be and comply with them. And that's going to take a lot of work between employers and payroll to make sure that's done as quickly as possible. So there will be significant impacts on payroll. And again, as I said, the danger of non-compliance, of making errors in payroll, is that errors can compound. So it's important to catch the errors as quickly as possible and fix them as quickly as possible so that they don't compound.
Perfect. And final question that we've got time for today. So apologies if we haven't come to yours, anyone else out there that has asked. My question is in regards to pay equality. I have two employees who do the same role. However, one gets paid more than the other. Is this a risk to my business?
It is a risk if there is not a good reason for the difference. Now, anybody can make a claim and say, listen, I don't believe I'm being paid fairly, and they have a right to make that claim. What an employer has to do is show that if there is a difference in pay rates, it's for a very good reason. So, for example, you might have a male, and the gender obviously is the main issue around payroll equity. A male who's been working for 5 years is doing the job very well with a lot of experience, and a female comes in with 1 year's experience, is not earning the same pay, but is doing exactly the same job, just at a slightly reduced level of complexity and competence because of lack of experience. She would then make a claim saying, listen, I'm being paid $2 an hour less than the male. And the employer would be able to turn around and say, well, yes, but there is a reason for that. That is a good, objective, and justifiable reason. In that case, there may not be a reason for pay to be made equitable in those two categories. However, if there was no obvious reason for the difference in pay, and it looks like it's just because of gender, then there's a significant risk to the business that they are paying unequally on the basis of gender, which is not appropriate.
Perfect. Okay. Well, Vaughan, thank you very much for your presentation today. I'm sure everyone else here appreciates the work you've put into this. That is all the time we've got for today. Feel free to touch base with either myself or Vaughan. You can connect with us via LinkedIn, or there are contact details up in front of you at the moment as well. On behalf of all of us here at HR Assured, thank you once again for joining us today, and I look forward to speaking with some of you soon.
Thank you. All the best.